Let's see. There must be something going on in the jail because they've not put them on yet. I'm gonna call down.
Good afternoon, Your Honor. Sorry for the delay. We are all in the room ready when you are.
Okay, thank you. On the record, in the matter of the people of the state of Michigan versus Paul Coachella, file number is 18-01980. You, Mr. Paul Coachella?
Yes, I am, ma'am.
Okay, sir, today's the date set for an arraignment on a failure to pay. Looks like you owe $885 from a domestic violence conviction from 2018. You were supposed to make payments. I think you did do a term of probation. Well, you were sentenced to a term of probation before Judge Buchanan. Looks like you had a probation violation hearing back on October 15, 2018. Your probation was revoked and you were sentenced, it looks like, to 60 days in jail. There was a show cause for you back on February 5th, 2019, for failure to pay, and you did not appear. Do you recall this case at all, sir?
I do. I was also in the process of going to rehab when all of this was going down.
Okay, and
So I didn't know anything about the warrant until I got picked up today.
Okay, so you still owe a balance on this file of $885. Are you currently employed?
Yes, I am, and I'm willing to pay, do a payment plan if that's possible.
Okay, that is absolutely possible. Let's see what's going on here in this file. Because I see at your probation status, you were sentenced to probation July. But then your probation looks like it was revoked a couple months later in October of that year. Some of these fines include oversight fees for 12 months, but you were not on probation for 12 months. So I think that needs to be addressed. Let's see, how much can you make a payment on, and when can you make, how much can you make a payment of, and when can you make a payment on?
I get paid every 2 weeks, so I got paid this week, so I get paid in another 2 weeks, and I can at least put 40 down every 2 weeks.
Okay, so I am going to adjust your balance because it looks like there was a $200 fine that was assessed, so you'll pay that, plus the crime victim rights fee, you'll pay that, and the $50 state minimum cost. You're also responsible for that.
All right.
Let's see here. I'm going to waive the supervision fee. I'll waive $300 of the probation oversight fee because your probation was revoked. Looks like about 2 months into your probation status. I'm gonna waive the $200 attorney fee. And that's because at this point, the public defender's office doesn't necessarily assess that anymore. And this was assessed under a different system where you had a appointed attorney through the court appointed system, which they don't have anymore. So I'm gonna waive that for you. I'll waive $300. So that'll take $500 off your balance. You owe $385.
So that's how much I have left to pay.
That's correct.
All right, thank you.
Okay, so you'll make a payment of $40 every 2 weeks until paid in full, and you're gonna make your first payment, you said, in 2 weeks?
Yep,
Okay, today is the 13th, so 2 weeks from today, a Friday, will be September 1st.
yep.
You know how to make payment?
I do not, but I'm pretty sure if I can get a hold of somebody that works at the court system here, I
I'm
can
gonna tell
figure
you,
out how to do it.
well, I work at the court system, so I'll tell you. You can come in person and make a payment at the criminal traffic counter here at City Hall on the 6th floor, or you can go to the court website. You would use your case number, which is the 18-01980 number. You can make a payment
Okay.
online, or you can mail check or money order to the court with your case number, okay?
All righty, thank you.
Do you have any questions?
I do not.
Okay, you're all set. Thank you. Okay. On the record, in the matter of the people of the state of Michigan versus Mashana Marvin. Okay, are you Mashana Marvin?
Yep. Yes.
Okay. Today is the date and the time set for an arraignment. I have a counsel appearance. You're muted.
Sorry, Your Honor. Good afternoon, Assistant Public Defender Stephen Feigelson, appearing on behalf of Ms. Mervina for arraignment this afternoon, Your Honor.
Thank you. Okay, so Ms. Marvin, today is the date set for arraignment, and I do have a misdemeanor complaint here, and it alleges that on or about August 12th, 2023, at the area of 4501 Lowcroft, which is in the city of Lansing, Ingham County, state of Michigan, that you did allegedly, contrary to law, commit the act in count 1 of domestic violence. The allegation is that you did make an assault or an assault and battery upon a Nathan Vance, a resident or former resident of your household, or an individual with whom you had a dating relationship, and that this was done contrary to Michigan Compiled Law 750.812. Restitution may be ordered as this offense may have resulted in damage to another individual's property or physical injury or death to another individual. This is a misdemeanor with the maximum penalty being 93 days in jail and or $500 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. There's a count 2 of breaking and entering, illegal entry without the owner's permission. The allegations, ma'am, are that you did enter with or without breaking or certain building or structure, to wit, a house located at 4501 Lowcroft, whether occupied or unoccupied, without first obtaining permission to enter from the owner or occupant, agent, or person having immediate control thereof, and that this was a violation of Michigan Compiled Law 750.115. Restitution may be ordered in this offense as it may have resulted in damage to another individual's property or physical injury or death to another individual. This is a misdemeanor with the maximum penalty being 90 days in jail and or $500 in fines. Do you understand the charges read in counts 1 and 2 and the maximum penalty in each count? Okay, you have the right to be represented by counsel. Mr. Feigelson from the Public Defender's Office is here to represent you for the purposes of your arraignment only. You have the right to have an attorney represent you throughout the pendency of this criminal prosecution, and you have the right to be represented by counsel if you're questioned by law enforcement. If you cannot afford to hire an attorney, but you economically qualify An attorney can be appointed to represent you at the expense of the public. Do you understand your right to counsel?
Yes,
Okay. And you have the right to remain silent. Anything that you say, anything you put in writing can be used against you. You have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, this matter will proceed to a trial. You have the right to have a jury trial in this matter. At the time of your trial, you have the right to the presumption of innocence. So you're innocent until proven guilty. You have the right to require the prosecution to prove your guilt at trial by proving each element of the charge being brought against you, or the charges being brought against you, and they have to prove each element of the charges beyond a reasonable doubt. You have the right to remain silent at trial and not have silence be used against you. You have the right to see, hear, or question and confront any of the witnesses in court that the prosecution intends to call against you. You have the right to call your own witnesses to testify on your behalf in court or present evidence in court that you believe further a defense to the charge being brought against you. Do you understand your rights?
yes,
Okay. Are you currently on probation or on parole?
No.
Okay, is she requesting court-appointed counsel?
Yes, she is, Your Honor.
Okay, and the court will enter a plea of not guilty on your behalf at this time. You're currently scheduled for a pretrial conference before me, Judge Kristen Simmons. It's going to be August 28th at 10:30 in the morning. Did you get a copy of the notice to appear and Zoom instructions for my courtroom?
yes,
Okay, you can appear via Zoom, but you need to have a video. And you also need to be in an environment that's appropriate for you to hold court. So you can't be driving or in a loud place, okay?
yeah, okay,
Okay. Are you currently employed?
yes.
Where are you employed?
I work at Deja Vu,
Okay. And what's your home address?
2385 Cedar Park Drive, Holt, apartment 109.
What's your phone number?
727-285-9717.
You can address bond counsel.
Yes, Your Honor. Miss Marvina lives in the Holt area, Your Honor. She grew up in the Holt area. She graduated from Holt in 2011, Your Honor. She has no prior criminal history. I'd ask for a PR bond this afternoon.
Bond will be set in the amount of $500 personal recognizance with a no contact order in place for the protection of the alleged victim, Nathan Vance. You're not to be within 1,500 feet of Mr. Vance, okay?
Okay. I don't understand the 500 part.
What that means is, I said personal recognizance, so you just need to understand that personal recognizance means that I am releasing you without you having to pay anything. And the expectation is that you'll follow the rules and the order of the court as it relates to your bond conditions, okay?
I understand.
Okay, so one of those bond conditions is that you need to appear for court. The other is that there's a no contact order. So you can't have contact with Mr. Vance, not directly, not indirectly, no third-party contact, no text messages, no notes, no contact of any kind. You understand that?
I understand.
Okay, and then again, you're not to be within 1,500 feet of wherever he is. You're not to use, purchase, or possess alcohol or drugs unless you have a valid prescription. You're not to travel outside the state without prior approval of the court. You're not to possess a firearm or any other dangerous weapon. And do you have any questions about your bond conditions?
No, I understand.
Okay. Any additional matters for the record, counsel?
No, Your Honor, thank you.
You're all set, ma'am.
Thank you.
You're welcome. I think I only have one file. Am I supposed to only have one file for Garza?
Yeah,
Yes.
Okay, okay, on the record in the matter of the people of the state of Michigan versus Angelo Garza, file number 23-01174FY, council appearance.
Yes, Your Honor. Good morning or good afternoon, Assistant Public Defender. Appearing on behalf of Mr. Garza, who's present here as well this morning or this afternoon.
Good afternoon, Mr. Garza.
Good afternoon, Your Honor.
Okay, Mr. Garza, today is the date we're arraigning you on a failure to appear before my court. You were supposed to be before me for a preliminary examination, and you failed to appear on August 10th. What happened?
Yes, Your Honor, I was at a 30-day rehab center, CPI in Waterford. And I missed my court date.
What center were you at?
CPI in Waterford.
CPI Waterford? When did you
Yes.
get admitted there?
What did I do? What? I didn't
When
get
did you
admitted.
go there?
Probably around the middle of last month. It was just for 30 days.
And I think he was released on Friday. Is that correct, Mr. Garza?
I think so. I'm not positive.
Okay, I'm just looking at the old note. I think he was previously in House of Commons. It looks like you held, Judge Flores held the PCC for me, and then you were supposed to continue to exam. So the matter will be reset for a exam. What's your address?
830 Vanguard.
830 what?
Vanguard.
Okay. And what's your phone number?
517-894-9492.
Okay, so you'll get a new notice in the mail for your examination. You need to make sure you get in contact with your attorney as well, okay?
Yes, Your Honor.
Is he represented by Mr. Goodrich?
Our records show Miss Donnelly.
Okay, so you need to get in contact with Sarah Donnelly from the Public Defender's Office, okay?
Yes, Your Honor.
Okay, and so there should be no excuse or reason why you missed your next court date, correct?
Correct.
Okay, bond will be set at 3,000 personal recognizance. All your previous bond conditions from the time of your arraignment, which include no use of drugs or alcohol without prescription, no possession of a firearm or dangerous weapon, and that you cannot travel outside the state without prior approval of the court, and you need to be reporting to pretrial services weekly. You need to report to them tomorrow, okay?
Yes, Your Honor.
Okay, do you have any questions?
No, Your Honor.
You're all set, thank you.
Thank you, Your Honor.
No problem.
Some paperwork?
yep, step all the way up.
No, so it's not the paperwork.
Just a second.
Is that a felony or is that a misdemeanor, Mr. Garza? Because I think the notes, the records that we have was a misdemeanor.
It's a FT file. Let's see. Vehicle flee. It's a felony. 5 years, and he's been charged as a habitual
Is
offender.
it a new
Second
felony or
offense.
was it in warrant status? Because I'm not seeing it in the system.
This was in warrant status. He's already been arraigned. He was arraigned back in April. And then he failed to appear for his PCC. So then we reset it again. And it looks like he saw Judge Flores in my absence. And the exam was scheduled for June 23rd. But
Oh,
he
I
was in
found it.
house.
I think.
Yeah, so
Sorry for the confusion, Judge.
no worries. So yeah, this is a police officer fleeing third degree habitual offender second offense notice. Okay, we're on the record in the matter of the people of the state of Michigan versus William Curtis Hill. This is Mr. Hill. He can have a seat. It doesn't look like he can stand well.
Yeah, I'm gonna do my chair.
Oh, okay, very good.
You can sit that way. There you go.
Okay, Mr. William Hill, can you hear me?
Yes, Your Honor.
Okay, counsel appearance.
Yes, Your Honor. Good morning, Assistant Public Defender Stephen Feigelson appearing on behalf of Mr. Hill.
Okay, Mr. Hill, today's the date and time set for an arraignment. I actually have another file for you here too, people of the state of Michigan versus William Hill, file number 23-01017 FY. So you'll be arraigned on both these files today. The first file, I have a felony complaint here and alleges that on or about August 12th, 2023, at the area of 524 North Chestnut in the city of Lansing, Ingham County, state of Michigan, that you did allegedly contrary to law commit the act in count 1 of controlled substance, possession of methamphetamine ecstasy. Are you all right? Or you're holding your head?
Blocking the light from my eyes, Your Honor, I'm considered legally blind, so I can't see the light.
Okay, so the light in there's a light in your eye?
Yeah, the light right up top there, I'm sharing so I can see the TV.
Sounds good. Oh, so count 1 is controlled substance, possession of methamphetamine ecstasy. It alleges that you did knowingly or intentionally possess methamphetamine contrary to Michigan Compile Law 333.74032BI. That's a felony. The maximum penalty is 10 years in prison and or $15,000 in fines. There's a count 2 of domestic violence. It alleges that you did make an assault or an assault and battery upon a Tamara Ivy, an individual with whom you have a dating relationship, and that this was done contrary to Michigan Compile Law 750.812, and that is a misdemeanor. Maximum penalty is 93 days and or $500 in fines, and a consecutive sentence may be imposed under the law. If the assault was committed in a place of confinement, restitution may also be ordered in count 2, as that offense may have resulted in damage to another individual's property or physical injury or death to another individual. There's a second offense notice. It says, take notice that the defendant was previously convicted of assaulting and battering his or her spouse, former spouse, or individual with whom he or she had a dating relationship, an individual with whom he or she had a child in common, or a resident or former resident of his or her household, or of knowingly assaulting a pregnant individual by violating Michigan Compile Law 750.82 on or about February 6, 2002, and therefore upon conviction will be subject to an enhanced sentence under Michigan Compile Law 750.814. That makes this a misdemeanor with the maximum penalty 1 year in jail and or $1,000 in fines. And again, a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. You understand the charges read in that file and the maximum penalty and second offense notice enhancement?
No, Your Honor, I didn't understand the last part you read about the child or brief something in there. I don't know anything about that. I do not understand that.
You don't understand the last part about what?
About something about a child or an individual pregnant or.
Oh, yep, I can explain that for you. So what the second offense notice was stating is that you were previously convicted of domestic violence or assaulting or battering your spouse or your former spouse, or it could have been an individual you were dating, or it could have been an individual that you had a child in common, or it could have been an individual that you lived with, or it could have been a pregnant person. So that's just saying the category of person that you were previously convicted of assaulting. So not necessarily saying that you assaulted a pregnant woman, it's just saying you were previously convicted of assaulting or battering someone in one of those categories, okay? And that was back on February 6, 2002. Do you understand that?
February 6, 2002.
That's what it says. I have your criminal history here.
Okay. There had to be something about, there had to be something against my wife or future wife or whatever.
You said it had to be what, sir?
Something about among my wife at the time that
I'm
I
not,
was married.
I can't speak to it. Maybe it was, maybe it was not. I do see, I do see, if you're gonna let me speak, I do see a conviction from 2002. I don't know who it was, but your attorneys can provide you further information along the line, okay? But you now understand what the second offense notice is saying,
Yeah,
sir? Do you understand the charges in that file and the maximum penalty attached to each of those charges?
yeah, I understand what you said, Your Honor. I understand.
Okay, thank you. So file number 23-01017, you have a felony complaint there as well. This one alleges that on or about March 22nd, 2023, in the area of 525 North Chestnut Street, City of Lansing, Ingham County, State of Michigan, that you did allegedly in count 1 commit the act of controlled substance delivery manufacturing of methamphetamine. It alleges that you did possess with the intent to deliver the controlled substance methamphetamine contrary to Michigan compiled law 333.74012BI. That's a felony with the maximum penalty being 20 years in prison and or $25,000 in fines. There's a count 2 of weapons, firearms possession by felon. The allegation is that you did possess a firearm when ineligible to do so because you had been convicted of controlled substance delivery manufacturing of a specified felony, and that the requirements for regaining eligibility had not been met contrary to MCL 750.224F. That's a felony. The maximum penalty is 5 years in prison and or $5,000 in fines, and there's a mandatory forfeiture of the weapon or device required under the law. There's another count 3 of weapons, firearms possession by felon. Again, it states that you did possess a firearm when ineligible to do so because you had been convicted of a controlled substance delivery manufacture, which is a specified felony, and the requirements for regaining eligibility had not been met, and that this was contrary to MCL 750.224F. Again, a felony, maximum penalty 5 years and or $5,000 in fines, and there's a mandatory forfeiture of the weapon or device required under the law. Counts 4 and 5 and 6 are all weapons, felony firearm. Count 4 reads that you did carry or have in your possession a firearm, to it being a pistol, at the time you committed or attempted to commit the felony of possession with intent to deliver methamphetamine, contrary to MCL 750.227B. Count 5 alleges that you possessed or carried a firearm, that being a pistol, at the time that you committed or attempted to commit the felony of felon in possession. And then count 6 alleges that you did carry or have in your possession a firearm, that being a shotgun, at the time that you committed or attempted to commit the felony of felon in possession. This is contrary to MCL 750.227B. Counts 4, 5, and 6 are all felonies. Maximum penalty in each is 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. In counts 4, 5, and 6, there's also a mandatory forfeiture of the weapon or device required under the law. There is an habitual offender second offense notice. It says, take notice that the defendant was previously convicted of a felony or an attempt to commit a felony, and that on or about July 25th, 2007, he was convicted of the offense of controlled substance delivery manufacture in violation of Michigan Compiled Law 333.74012A4 in the Circuit Court for Ingham County, State of Michigan. Therefore, defendant is subject to the penalties provided by Michigan Compiled Law 769.10, making the penalty 1 1/2 times the maximum sentence on the primary offense or a lesser term. The maximum penalty cannot be less than the maximum term of the first conviction. Mr. Hill, do you understand the charges read in count 1
No,
through
Your Honor,
6?
I understand those charges. The first time I ever heard most of those charges, and I don't know anything about none of those charges, okay? I have no paperwork and nothing that's sent to me. I have nothing to address me of none of those charges you are reading, okay? Except for maybe 1 or 2. Okay, the one maybe in 2002 about the message, yes. Okay, when the firearm carry, okay, I had the firearm, okay. I had been convicted of felony. I had no felony at the time that they searched me with the firearm. Okay, I went to court on that. They're still pending in the court. I haven't heard anything back from them on that. That's the only 2 things that I heard about on that. This stuff, and for this one I'm in here for now, for the message goes against the Mayor Ivory, there's a bunch of crap because Mayor Ivory stole $100 and some out of my pocket, and I asked for my money back.
Mr. Hill, I advise you anything you say is being recorded, so please stop talking.
Thank you. The question I asked is, do you understand the charges? I didn't ask you, did you agree with the charges? I said, did you understand them? Understanding is just basic comprehension of what I just read. Do you comprehend what I read?
I comprehend what you read.
Thank you. You have the right to remain silent. Anything that you say and anything you put in writing can be used against you. You have the right to be represented by an attorney. Mr. Feigelson is here to represent you for the purposes of your arraignment. You have the right to have an attorney represent you throughout the pendency of the prosecution of both of these files. You have the right to request the public defender's office to represent you at the expense of the public if you can't afford to hire your own attorney. You have the right to plead guilty. You have the right to plead not guilty, or you can stand mute. If you stand mute, we'll proceed all the way to trial in each of these files. Both of these files, sir, you have are facing felonies, and so you have the right to have a preliminary examination on each of these files. You have the right to have the preliminary examination within 21 days of today's date. Today's date is the date of the arraignment. And at the time of your preliminary examination, you have the right to require the prosecution to meet their burden of probable cause. So you can require the prosecution to establish at the preliminary examination that they have sufficient probable cause that a crime was committed, and then probable cause sufficient to charge you with the crimes alleged. You have the right to proceed to trials in these matters. You have the right to have a jury trial. At the time of your jury trial, you have the right to the presumption of innocence. So you're innocent until proven guilty. You have the right to require the prosecution to prove your guilt by proving each element of the charges being brought against you in each file beyond a reasonable doubt. You have the right to call witness to speak for you at trial. You have the right to see, hear, or question all the witnesses against you at trial. You have the right to remain silent at trial and not have silence be used against you. Do you have any questions so far?
No, Your Honor.
Okay, let's see. Is he requesting court appointed counsel?
Yes, he is, Your Honor.
Okay, you are currently scheduled probable cause conference on the newest file before Judge Stacia Buchanan. You have probable cause conference before her on August 25th, 2023 at 9 o'clock in the morning. And then you have a preliminary examination in person at the court before Judge Buchanan, September 1st at 9 o'clock in the morning. Did you get a copy of your notice to appear?
Did I get a copy?
Did you get a copy of a notice to appear?
Maybe I did, Your Honor. I got something here, but I have to see it because I can't see right now. I have to have someone to read it to me. Okay, I got the paper right now.
Sounds good. And so the other file, the file number 23-01017, also needs to have a PCC, which is a probable cause conference. And it also needs to have an exam date. I'll have those set for the same date and time as the other files so that you don't need to appear in court multiple times, okay?
Yes, Your Honor. I think I have a court appearance on the 26th of, I think it's October.
You do. That's probable cause conference before Judge Buchanan on August 25th.
No, the 26th.
The 25th.
Okay.
Did you get a notice? Can you hear me?
Yes, ma'am, Your Honor. I can hear it. I guess, is this another?
Yes, you.
Yes, this is another hearing, sir. I got that.
Okay.
And one other thing, Your Honor, I would like to make sure that they examine my address to make sure my address is right. They send the paperwork and stuff.
Don't worry, I'm gonna go over your address in just a moment. Don't you worry. Okay. Are you currently on probation or parole?
I don't think I'm on probation. No.
You don't think?
I don't think I'm on, no, I'm not. I'm not on probation, bro. I'm just pending court again.
Okay.
I don't know.
And are you on parole?
No.
Did you hear my question, sir?
Yes, ma'am, I did, Your Honor.
Are you on parole? Okay, thank you.
I'm on parole, probation.
For the record, the court is entering a plea of not guilty on your behalf on each file, noting also that you are requesting court-appointed counsel. Are you currently employed?
No, Your Honor, I'm retired. I'm 73.
Are you currently on bond in any other matter?
Pardon me?
Are you on bond on another matter?
I think so. Yeah, I have I believe so.
No, she is.
So, yep. You have a matter bound over to the circuit court?
Yes, I have a matter to bound over to, yes.
Sounds good.
He also has 2 misdemeanors in front of Judge Flores as well, Your Honor.
Okay, I think I see that on here too. Okay. Okay. What's your home address?
524 North Chestnut, Lansing, Michigan. 48933.
Okay. Well, that's exactly the address we have. You said you believe we have the wrong address?
Well, yes, Your Honor, they did have the wrong address, but I don't know what they had it, but somehow through the record, they sent some papers to the wrong address and I didn't get it. That's why some of those code appearances didn't make because they went somewhere else. We already discovered that and figured it out and it didn't happen. They apologize for that and reschedule. But I want to make sure.
Sounds good. What's your phone number?
My phone number is 517-348-6053.
Counsel, you can address bond.
Yes, Your Honor, Mr. Hill is 73 years old, Your Honor. He is on a fixed income. Obviously, he has several matters pending before these courts. Given his age, I do believe he has limited criminal history, Your Honor. I'd ask for a PR bond or a low cash surety bond today.
We got two files here. One of them, he's got a felony with a second offense notice and a domestic violence. And then the other one, he's got 6 counts. Three, and another habitual offense notice. And then I have 2 pending misdemeanors that he's currently on bond for, and a felony matter before the circuit court that he's currently out on bond for, which means that he would be under court order at the time that he picked up at minimum this first case that I arraigned him on today. So a personal recognizance bond would be not appropriate. The age of his current age doesn't have any bearing on the concern about the threat to the public safety and his ability to follow the court orders and his ability to appear in court as he's ordered to do so. There will be bonds set in each of those matters, but they won't be personal recognizance. The new file, the bond is going to be set in the amount of $2,500 cash surety. And then file number 23-01017. Bond is set in the amount of $3,500 cash surety. While out on bond, there's the following conditions. You're not to use, purchase, or possess any drugs or alcohol unless you have a valid prescription. You're not to travel outside the state without prior approval of the court. You're not to possess a firearm or any other dangerous weapon. You need to report to pretrial services within 48 hours of your release. There's a no contact order that's going to be in place for the protection of Tamara Ivy. You're not to be within 1,500 feet of wherever she is. That includes wherever she lives, works, or goes to school. You're not to have contact directly or indirectly with Tamara Ivy. Do you understand each of your bond conditions?
Yes, I understand that. The last part that with Tamara Ivy, and she to be contacted, come see me or come to my house, a place where I be, or she to do that. But that's what she did. I haven't contacted her. She contacted me.
Okay. If she comes to your house, you're not to let her in.
What I'm supposed to do? Call the police?
Absolutely. If she comes to your house, you don't let her in. You don't let her inside of your house because there's a no contact order. And so if she breaks in, you need to call the police. You understand that?
Yes, I understand that, but somehow that just haven't been happening. You know,
Okay, sounds good. So it looks like we have an understanding going forward as it relates to the no contact order. And you need to make sure you appear for all of your court dates. Any additional matters for the record, counsel?
No, Your Honor, thank you.
You're all set, sir. be Mr. Plummer, because you're anxious to get up and have your turn. Are you Mr. Plummer?
Yes, ma'am. Absolutely.
Okay, on the record, in the matter of the people of the state of Michigan versus Darnell Plummer, council appearance.
Yes, Your Honor, good morning or good afternoon, Assistant Public Defender Stephen Feidelson appearing on behalf of Mr. Plummer today.
Okay, Mr. Plummer, I have 3 files for you. We'll start with the new one. I have here a felony complaint that alleges that on or about February 1st, 2023 through the range of August 13, 2023 at the area of 4821 Wainwright, City of Lansing, Ingham County, State of Michigan, that you did allegedly contrary to law commit the act in count 1 of home invasion, 1st degree. The allegation is that you did break and enter or did enter without permission a dwelling located at 4821 Wainwright with the intent to commit an assault therein and while entering, present in, or exiting the dwelling, Olivia Oglesby was lawfully present therein, and that this was done contrary to MCL 750.110A2. It also alleges that is a felony. Maximum penalty is 20 years in prison and or $5,000 in fines, and a consecutive sentence may be imposed for any other conviction arising out of the same transaction. There's a count 2 alleging that between the dates of February 1st, 2023 and August 13th, 2023, you allegedly committed the act of stalking aggravated. It alleges that you did engage in a willful course of conduct involving repeated or continuous harassment of Olivia Oglesby, the conduct being such that would cause a reasonable person to feel terrorized and or frightened and or intimidated and or threatened and or harassed, and said conduct actually caused Olivia Oglesby to feel terrorized and or frightened and or intimidated and or threatened and or harassed, and at least one of the actions constituting the offense is in violation of a restraining order the defendant has received actual notice of and or a condition of pretrial release contrary to the Michigan Compiled Law 750.411I. That's a felony. The maximum penalty is 5 years in prison and or $10,000 in fines and probation for any term of years not less than 5. Do you understand the charges just read in this file and the maximum penalty in each?
Oh, yes, sir. The first charge you said was home invasion, and the second charge is what again?
Okay,
I'm
at
sorry.
first, count 1, home invasion 1st degree, and then count 2 is aggravated stalking.
From how do you get the dates though? I don't understand. Like
The date is a range. I don't factor or figure out the date. That's not something I do. I'm here to read the charges. And so their allegation is that this count 1 and count 2 took place during the time ranges, at least the stalking did. The stalking was between February 1st, 2023 and August 13th, 2023.
oh, so the whole time. That's what you're saying?
That's the allegation, is that during that time range from February 1st until today, you've been engaged in an act that constitutes aggravated stalking.
Do they know this woman has bailed me out of jail, like, and everything between?
I'm sorry?
I'm
sorry, I didn't hear your
Mr. Plummer, I would not say anything more. This is recorded right now.
Do you understand the charges and the maximum penalty?
Yes, ma'am, Your Honor.
Okay. This is a question about whether or not you can comprehend what I'm saying, not do you agree with what I'm saying. I'm not asking you about are you guilty or not guilty. I just want to know if you understood the charges, and that's all I'm asking, okay?
Yes, ma'am, Your Honor. I honestly, not even to like play stupid or anything, but I do not understand those charges. I don't. The second one, the second offense, the first one.
The aggravated. Okay, so is it the date range that you don't understand, or you don't understand what aggravated stalking is?
I mean, I could kind of picture what aggravated stalking is, but the dates.
Okay, so the date range, aggravated stalking, the allegation is that it was a continuous activity or that it happened in multiple times between the date ranges of February 1st up until or today.
Okay,
That's what that date range is, okay?
yes,
Does that
ma'am.
explain that better for you?
Yes, ma'am.
Okay, and so you have the right to be represented by counsel, and Mr. Feigelson is here to represent you for the purposes of your arraignment only. But you have the right to be represented by an attorney at each stage of the criminal prosecution. You have the right to have counsel appointed to you if you can't afford to hire an attorney. Do you understand your right to counsel?
Yes, ma'am.
You have the right to remain silent. Anything that you say, anything you put in writing can be used against you. You have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, we'll proceed to trial on this matter. All right, because you are being charged with felonies in this, you have the right to have a preliminary examination, and you have the right to have that examination within 21 days of today's date, that date being the date of your arraignment. And that 21-day timeline can only be moved if the court finds good cause to go beyond that 21 days, or if you waive the 21-day timeline yourself. At the time of your preliminary examination, you have the right to require the prosecution to meet their burden of probable cause. So the preliminary examination, you can require the prosecution to establish first that they have sufficient probable cause that a crime was committed, and also sufficient probable cause to charge you with the crimes that they have alleged that you committed. Do you understand those rights so far?
Yes, ma'am, Your Honor.
Okay. You have the right to a jury trial, and you have the right to the presumption of innocence at the time of your trial. So you're innocent until proven guilty. You have the right to require the prosecution to prove your guilt by proving each element of the charge being brought against you, or the charges being brought against you, beyond a reasonable doubt at trial. You have the right to remain silent at your trial and not have silence be used against you. You have the right to see, hear, or question any other witnesses the prosecution intends to call. You have the right to call your own witnesses or present evidence at trial that you believe further a defense to the charge being brought against you. Do you have any questions so far?
No, ma'am, Your Honor.
You have the right to be considered for pretrial release from custody. We'll address your bond in just a moment. Are you employed?
No, ma'am. Nor do I have a phone number nor address. I'm homeless right now.
Okay, so you're unemployed, you don't have a home phone number, and who's the Ingham Street address belong to?
A relative.
Where are you sleeping?
Streets.
You sleep on the streets?
Yes, ma'am.
Okay. And you have no phone number?
No, ma'am, not a working one.
Okay.
Last phone number I lost. Though I lost the phone, it was a free phone from the government.
So the court will enter a plea of not guilty on your behalf. Is he requesting court-appointed counsel?
Yes, he is, Your Honor.
Okay, we'll note that you're making a request for court-appointed counsel. You have a probable cause conference scheduled in this matter before Judge Ward. It's going to be on August 24th, 2023 at 9:00 in the morning. You have an in-person preliminary examination before Judge Ward August 31st at 8:30 in the morning. Did you get a copy of your notice to appear before Judge Ward?
Yes, ma'am, Your Honor.
Have you ever missed court before?
Yes, ma'am.
Looks like you might have a bench warrant before Eaton County. Let's see. 56A District Court. Do you have a bench warrant that you need to address over there?
Yes, ma'am. I'm supposed to get sentenced on a matter, and I just missed the sentence, and that's the court date that I'm talking about. I missed. It's already resolved. I just had to get sentenced on it.
Well, it's still, it shows me as of today, you're still in bench warrant status over there.
Yes, yes, Your Honor. Yes, ma'am.
File number 23-000655. It's a matter that you have a pretrial set before Judge Buchanan, at least. Looks like you should have had a pretrial set. You were supposed to go to jury trial, but you're in warrant status on that one, I believe. Why do you not have a jury trial date on this? I do have two PA 53 violations in this file. PA 53 violations being a violation of your bond conditions. There's a police report here on one from May 14th, 2023, alleging that you violated the terms of your bond conditions by making contact with the alleged victim, Olivia Oglesby, in violation of the no contact order. There's also a police report from May 9th, 2023. Again, the allegation is that you violated the terms of your bond conditions and on that date and time by making contact with the alleged victim, Olivia Oglesby, and that you were also in violation because you were ordered not to commit a crime while released, and you allegedly picked up a new charge. You were ordered not to harass, intimidate, beat, molest, wound, stalk, threaten, or engage in any other conduct that will place any of the following persons or a child of the following persons in reasonable fear of bodily injury, that being your spouse, your former spouse, individual with whom you had a child in common, or a resident or former resident of your household. It's also an allegation that you violated your bond by violating the condition that you were not to assault, harass, intimidate, beat, molest, wound, or threaten Olivia Oglesby, and that you were not to have contact, third party or otherwise, or directly or indirectly, with Olivia Oglesby, and that you violated the terms of your bond conditions because you were only allowed to be at the area in which Ms. Oglesby resides one time to remove personal belongings, and that you were not to be within 2,000 feet of wherever she lived, works, or goes to school. And then there's a new PA 53 violation from this new police report. Again, I have a police report from August 12th, 2023, again, alleging that you violated the terms of your bond conditions because you were not to have contact directly or indirectly with Olivia Oglesby, and you were not to enter the property where she lived. And the allegation, as read in the new case that I arraigned you on, alleges that you violated that. So you have the right in each of those violations to have a contested hearing. You have the right to have evidence brought forth to establish beyond a reasonable doubt whether or not you violated the terms of your bond conditions as alleged. However, due to the PA 53 violations, which are contempt of court orders, you can be sentenced to the following. You can have a sentence of 93 days in jail on each violation and or up to $7,500 in fines. Your bond can also be revoked pending these matters prosecution. Do you understand the PA 53 violations?
Yes, ma'am, Your Honor.
Okay, do you have any questions at this time?
No, ma'am, Your Honor.
Okay, counsel, you can address bond. You're actually muted, Mr. Feigelson.
Sorry, Your Honor. Mr. Plummer is from here, the Lansing area, Your Honor. He's born and raised. I understand these are all allegations involving the same alleged victim here, but I let the court system play out before we assess anything more than that, Your Honor. I'd ask for the lowest possible cash bond with a percentage today.
Thank you. Okay, so I have here one new case with a home invasion first degree and a count two of stalking aggravated home invasion carrying a penalty of up to 20 years in prison and stalking felony with 5 years. Then I have a matter that you have a pending bench warrant in 56A District Court, and then you have another matter here before Judge Buchanan, which appears you failed to appear for your jury trial. And then I have now 3 pending bond violations. So and I don't actually see this particular violation in this file. I don't know why, but I do see a bench warrant which was signed by Judge Buchanan in the file that's pending for her for the defendant tampered with his GPS tether on April 28, 2023 and attempted to remove the tether. Are you on tether, sir?
No, ma'am, not anymore.
Okay. Did the judge order the tether be removed?
No, ma'am.
Oh, okay. And so the court has grave concerns about the protection of the alleged victim in this matter, as well as the concerns about the defendant's ability to follow the court's orders and appear in court. And so a personal recognizance bond would be inappropriate. In the new file, bond is going to be set in the amount of $20,000 cash surety with GPS tether and victim notification. a bond set in the file number 23-0065. It's gonna be 7,000. %. And that would be the file that you have the 3 PA 53 violations on. Let's see. File out on bond, you have to have contact directly or indirectly with Olivia Oglesby. Do you understand what that means?
Yes, Your Honor, I do.
So, okay, so that means no contact of any kind. You shouldn't be able or attempting to try to make contact by phone. You shouldn't be trying to email. You can't go to her house. You can't go where she works. You can't go where she grocery shops. You can't go where she does her laundry. You can't go where she worships. You can't go anywhere where you think she might be. You can't send a smoke signal. You can't contact her through any mechanism of any kind under any circumstances. Do you understand that?
Yes, ma'am, Your Honor.
Okay. And then you're not to have anybody else attempt to make any contacts on your behalf. Do you understand that?
Yes, ma'am, Your Honor.
Okay, very good. And you need to make sure you appear to all of your court dates. I am going to order here that you be remanded also so that you can address your bench warrant 56A. And then once that's addressed, you'll have to post our bonds here before you can be released, and you need to have a GPS tether with victim notification. Okay?
Yes, ma'am, Your Honor.
And then need to appear for all of your future court dates. You're not to possess a firearm or any other dangerous weapon. You're not to use, purchase, or possess drugs or alcohol without valid prescription. You're not to travel outside the state without prior approval of the court, and you need to report to pretrial services within 48 hours of your release. You'll be reporting to them weekly, okay?
Yes, ma'am, Your Honor.
Do you have any questions at this time?
No, ma'am.
Any additional matters for the record, counsel?
No, Your Honor, thank you.
Thank you. You're all set, Mr. Plummer.
All right, thank you. Have a good one.
Same to you. Thank you, Mr. Feigelson. Thank you in the jail.
Yeah, thank you, Your Honor. Have a good day and a nice weekend.
You too.
Did you get this way? Did you get this way?